Right. We were discussing the banker-customer relationship. Under that, we not the last week, previous week, we discussed the banker's rights and duties, banker-customer relationship, the nature of the banker-customer relationship, who is a banker, who is a customer, what is the nature of the banker-customer relationship. Then thereafter, we discussed the rights and duties of the banker, and I believe we have to start from this point today, that is customers rights and duties under the banker customer relationship. So okay, we'll start there. Now we know the who is a customer of a bank. We discussed last week, the customer means a person who has any type of account with the bank. So unless he open an account, he is not a customer of the bank, and there is no banker customer relationship between the bank and the so-called person. So therefore, banker customer relationship starts when a person open an account. Immediately after opening the account, that person become a customer, and the transaction, to do transaction, is not necessary to become a customer. Just to open an account is sufficient. So then we discuss about if a person has dealt with the bank without an account with the bank, but later if he open an account, he become a customer of the bank, not the date that he he opened the account with the bank, but he becomes a customer from the date he first dealt with the bank. So those are the things that we discuss, and we discuss certain cases to identify who is the bank, who is a customer. Right. So having those things in your mind, we'll go to this one. The customers' rights and duties under the banker-customer relationship. Okay, what are the rights of the customer under the banker-customer relationship? When a person open an account with a bank, he becomes a customer. And what are the rights that he gets under the banker-customer contractual relationship? As we discussed previous day, it's a contractual relationship. The banker-customer relationship is a contractual relationship. So under this, I said both parties, they have rights and duties. So what are the duties or what are the rights? First, we discuss the rights of the customer. What are the rights of the customer? Right. First one, to opening an account. The customer's right to opening an account. Now, this point, this right that you have to understand very, very correctly, because don't mislead yourself that this doesn't mean that anyone has a right to open an account with the bank. It is not the case. If bank allows a person to open an account, then what is the situation? What is the customer's right? Customer's right is, if we under this right to open an account, customer has a right to give instructions or to the instructions to the bank, or customer gives a mandate to the bank. So what do you mean by mandate? Can someone talk and explain me what is mandate? Anyone? Can somebody explain to me what is mandate? Satura, can you explain what is mandate? No. No one. Harshani, can you explain what is mandate? What do you mean by mandate? Okay, no one is answering. So okay, right. Then I'll go ahead. Right, a mandate means, now you see, customer, when he opens an account, so rather after opening the account, so accounts belongs to the customer. It is his account. It is not the account of the bank. The ownership of the account is with the customer, not with the bank. We call that is, we say it's Mr. Pereira. We say Mr. Pereira's account. We don't say it is bank's account, bank's own account, right? So it is the account, it is a property of that person, Mr. Pereira, the customer, right? So, however, he maintains the account in the bank, in the system of the bank. He maintains the account. It is not the bank maintains the account, it's the customer maintains the account in the bank. His property, his account, he maintains in the bank. Now, actually, if you see the operation of this account, who operate the account? Who operate the account? Though we say the customer operate the account, actually, physically, customer is not allowed to operate the account. Customer give instructions to the bank and the bank officers operate the account. For example, simple example, we say, I have an account in a bank. I want to deposit money. We say it's a savings account. So I go to the bank. We say not this internet banking, right? So normal banking practice that we know. We go to the bank branch and we get a deposit slip. We fill the deposit slip and we hand over the slip with the money to the teller, right? The teller go into the system, operate the account, he put money or credit the account. The customer never allowed to go into the system and put the money into the account unless internet banking is. It's different, right? Here, the operation part is done by the bank officers. Now the question is, what is the authority that bank officers have to operate the customer's account? If it is customer's account, if it is owned by the customer, and what is the right that we have as bankers to operate his account, right? So to operate the account on behalf of the customer gives a mandate to the bank. So mandate, in other words, we can define as the authority given by the customer to the bank to operate the account on behalf of the customer. That is very important. So what is the definition for the mandate? It is the authority given by the customer to the bank to operate the customer's account on behalf of the customer. So at what point the customer gives the mandate? Customer gives the mandate at the time of opening the account, right? The bankers know that we take a document called mandate card or mandate, the customer sign and give. So if you have read this document, I'm sure most of the bankers have not read the document, but you read next time. These documents, it has conditions, terms and conditions, and it says the customer gives a mandate or authority to the bank to operate his account and blah blah. There are so many other terms and conditions are there, but mainly by signing this document, the customer gives a mandate or authority to the bank to operate the account. So what is the condition? Condition is the bank officers, they have to maintain the account for the benefit of the customer or on behalf of the customer. So the customer's right at the by opening the account is this. Customer has a right to give instructions to the bank or give a mandate to the bank. Then the obligation, what is the obligation of the bank? On the other side, the obligation of the bank is bank has to act according to the given instructions or given mandate. That you have to remember. Most of the time we observe the bank officers, bank staff, they don't understand or they don't remember that they are the agent of the bank, of the customer, right? The principal is the customer, the bank officers or bank is only the agent. So agent has to follow the instructions of the principal. So that part, most of the time we forget. Bank officers, bank staff, they forget. So they think that that we can operate the account as we wish. It is not the case. So here that I have given a case, important case, Hurenberg versus Federal Bank of Australia. Hurenberg versus Federal Bank of Australia. So this case is very important with regard to the customer's right. So what happened in this matter? Customer had a current account with the bank. His account was overdrawn and it was overdue. Bank tried to contact the customer and ask him to settle the dues, but he failed. However, this customer, he deposited money to this current account. Now, under normal circumstances, you know, when a customer deposit money to his overdrawn account, current account, what happened? The money will be absorbed or will be set off against the OD balance. So here what happened? His account was overdrawn, but he gave money to the teller with specific instructions. I have bolded here, highlighted that part. With specific instructions he gave the money. So you are also have to be very careful when you are dealing with the customers. If customers give specific instructions, that you have to be very, very vigilant, right? So in this case, he gave specific instruction. What was the specific instruction? He said, the money that I am depositing is to meet a check that I have issued. So once the check comes for the clearance, please pay the check. Don't take this money to set off my, in other words, don't take this money to set off my OD. So that was the clear, the specific instruction given by the customer to the bank teller at the time of depositing money. However, what happened? This money deposited to this customer's account, manager of the branch, he took to set off the OD balance. So the manager, without informing the customer, set off the OD, and obviously the check got returned because insufficient funds in the account. Then what happened? This person, the customer, sued the bank. He filed action against the bank. So what happened? He won the case. It was decided that the bank has no right to set off the money against the overdraft when the customer has given instructions, specific instructions to the bank. So therefore, it is the first right of the customer is the customer has a right to open an account. If he open an account, he gives a mandate to the bank, and the bank has to obey by the instructions of the customer. That is number one of customers' rights. If you have any questions that you can ask, or otherwise I'll go to the next slide. So next one, the customer's right number 2, customer has a right to stop the account. Stop the account. Now this also you have to be very carefully understand, observe, because this is, here we are talking about the stopping the account, not closing. So next we are going to talk about the closing. Closing and stopping of the account are two different things. It is not the same, right? Anyway, if customer is allowed to open an account, he get a right to stop the account. the customer can seize the debit or credit, debit and credit both to the accounts until further notice. So that means customer can give instructions to the bank to stop debit and credit of his account for a period or further until notice. Further notice. So remember, so when you stop when the customer stop debit and credit both, that means the bank basically cannot uh, operate the customer's account. So what else you can do? You can do only the credit and debits. So if it is seized, stopped by the customer, the bank has no mandate authority to operate the customer's account. It could be for a period of time. The customer can give instructions to stop the account, we say, for 2 weeks. So the specific period mentioned. Or customer can say or give instructions to the bank to stop the account, debit and credit both, for until further notice. So that means it is stop till we receive instruction from the customer to reactivate the account. So then remember this thing, during this period, during the customer, the account is stopped by the customer, the bank should not honor any checks or pay any standing orders of the customer. So all the checks issued by the customer, you can't pay, you have to return the checks. And also, since no debit and credits are allowed, bank cannot pay the standing orders also. So standing orders, nothing you can do, or no debit or no credit during the period. So the bank can debit the account only to recover the losses and charges occurred before it received the stop notice. This is number 4 that you have to remember. Bank can debit the customer's account only for one reason. That is, that the bank can recover whatever the expenses, the losses, charges that had occurred before the bank received the customer's notice to stop the account. Now, for example, we say like this. We'll get this example. Customer's account is overdrawn. Customer's account is overdrawn and customer gives instructions to stop the account, we say, for a period of 3 months. Now, by the time we receive the customer's instructions, or rather notice, to stop the account is overdrawn, already overdrawn. So we know under the banking law, under the traditional banking law, when an account is overdrawn, the bank has a right to charge interest. So for the overdraft, we charge interest. Now, the question is whether we can charge interest for the overdraft because the customer has stopped the account. The answer is yes. The account was overdrawn before we received the stop notice. So therefore, the charge or the interest was due to the bank before we received the notice. So during this stop period, that we can charge interest for the overdraft that he has taken before. So, and the charges also same. So charges we charge for the services that we provide to the customer. We say the customer, we have provided the service to the customer 2 weeks before, and then thereafter we received a notice from the customer, stop notice. So we can debit the customers to recover the charges. For example, we say a customer has a loan facility. He has obtained a loan, and we say it's a housing loan, and he is supposed to pay insurance premium, but he has not paid. The bank has paid on behalf of the customer. Now the bank has to charge that interest premium from the customer. but the customer's account is now stopped. So for now, since the charge has been raised or has been became due to the bank before we receive the notice, we can then debit the customer's account. That is legal. Otherwise, we can't do any transaction if we receive notice of stop. Then what about the banker customer relationship during this period? Whether the banker customer relationship exists or whether it's over. The answer is stopping of account is not a permanent thing. You see, it's a temporary thing. The account is not closed, the account is just stopped. The banker customer relationship contract is not over. The banker customer relationship is there, it is existing. If the banker customer relationship is existing, definitely the duty of secrecy and other duties are there. So therefore, remember, just because the customer has stopped the account, it doesn't mean that the banker customer relationship is over. It is not so. The banker customer relationship prevails, and all the rights and duties under the banker customer relationship also exist. So therefore, we have to be very careful. Even the account is stopped, we can't divulge any information of the customer's account, and we abide by the other duties also. That is the right number 2 of the customer. If you have any questions or if you need any clarification, as I told you the previous day, that you can then and there you can ask the question. You can ask the question. You don't want to type and send. But if you wish, that you can type and send, but I will answer to those questions at the end of the lesson. Or otherwise, then and there you can ask the question by unmuting your microphone. That is number 2, the duty number, rather the right of the customer. Right number 2 we discussed. Now we'll go to the next one. The next one is number 3, to close the account. Customer has a right to close his account. Now, this closing of account is not a temporary thing. It's a permanent thing. When the customer or the bank close the account, that means the banker customer relationship comes to end. Right? So it's a permanent thing. It's not a temporary thing like stopping the account. So customer, once he opened the account under the banker customer relationship, he gets a right to close his account. In other words, he has a right to terminate the banker customer relationship by closing his account. Now, important point here is the customer has a right to close his account at any time. This word is very important. He has a right to close his account at any given time. It means the customer has no obligation to inform the bank or give prior notice before he closed the account. It is different from the bank's right. So therefore, you have to be very clean about this idea, to have it very clearly understand. Customer has no duty or no obligation to give prior notice to the bank before he closed the account. So he can close the account at any given time. So he can basically just come into the bank branch, walk into the branch and say that I want to close the account now. So don't argue with a customer like that, because he has a right for that. He has a right. You can't say that you have to give 3 days notice, 7 day notice. That is our practice. Nothing important. Your practice cannot supersede the law. Law says the customer has a right to close his account at any time. So then the banker customer relationship with the closing of the account comes to end. So closing of account is a permanent thing. So therefore, once the account is closed, the same account cannot be reopened. This is another thing that you have to remember. Same account you can't reopen. You can't allocate the same account number again. In other words, account is closed. When the account is closed, that is permanently closed. And if this customer wants to open another account, that he can do that. He can open another account. He can start a new banker customer relationship. He can open another account, but different account number, totally different account number that you can allocate, not the same account number. He can't continue the same. So then new banker customer relationship starts. Then what about the duty of secrecy? Duty of secrecy, once the banker customer relationship is over, can we then divulge the information of the customer? In other words, because the banker customer relationship is over, the answer is no. We should not divulge information. Duty of secrecy is there even though banker customer relationship is no more there. So the nature of the duty of secrecy is this: once the duty of secrecy started, it's never end. So when it starts, it never ends. It continues even after the customer closes the account. Even the banker customer relationship is over, that bank is not supposed to divulge any information of the customer to a third party without the consent of the customer. So that is that duty of secrecy part. Then when a customer, I said the customer has a right to give instructions to close his account at any time. So the question is whether he can give verbal instruction, whether he has to give written instructions. Can't we accept verbal instructions? Those are the questions that comes to our mind. So the answer is this: customer, it is not necessary or it is not mandatory to the customer to give written instruction. In other words, the bank can accept verbal instructions of the customer to close the account. So for basically, customer can give a telephone call and instruct the bank to close his account. So that is sufficient instructions. Bank has to accept the instruction. But there is an important case that you have to remember, that is Wilson versus Midland Bank. This is also, I believe, is an Australian case. As what happened in this matter, this customer gave instructions over the phone to close the account. The bank accepted the instructions, verbal instructions, and closed the account. However, the bank couldn't get written instructions of the customer. So later, what happened? The bank closed the account. The checks issued by this customer got returned, and then he sued the bank. He claimed, he accused the bank. He said, without instructions, bank has closed his account. So therefore, his checks got returned, and he faced a lot of damages or losses because the bank has illegally returned his check. So return his check by closing his account. So what happened in this matter? The bank couldn't establish that they got instructions of the customer, because the instruction given by the customer was verbal, and bank had not obtained written instructions from the customer. So important point here is bank can act upon the instructions, verbal instructions of the customer, but it is very important to obtain that instruction in writing also. So if you act on the verbal instructions of the customer. You have to remember, follow it, and take the written instructions for your record purpose. Otherwise, the customer himself can challenge the instructions one day. So therefore, be very careful when you are getting verbal instructions. That is number 3, the customer's right. Then number 4, customer's right. Fourth customer right is right to interest, right to get interest. Customer has a right to get interest for his deposits. For the deposits account, customer receive interest like savings account, fixed deposit, RFC, NRFC accounts. The customer has a right to receive interest. So what about the interest rate? Whether the customer has a right to decide the interest rate, or whether the bank has right to decide the interest rate. Whether the bank has right to change the interest rate once the interest rate is informed to the customer. Those are the questions that we every day that we face or comes to our mind. The point here is the rate of interest for these accounts like savings account, NRFC, RFC, it fluctuate with the prevailing market rate. So in other words, the bank has the right to determine the interest rate depending on the market rate, so market trends. However, for the fixed deposits, special types of accounts, the bank has no right to change the interest rate during the validity period of such fixed deposit. For example, if bank has agreed to pay, we say 15% interest for a fixed deposit, the bank has no right to change the interest rate during the validity of the fixed deposit. So bank can change the interest rate for fixed deposit at the maturity. If it is auto renewal fixed deposit, when it is renewed to the next term, the bank has right to change the interest rate. Or otherwise, if you promised an interest rate for a fixed deposit, the bank has to pay such interest rate. So normally the customers will not question if you increase the interest rate, but if you reduce the if you reduce the rate of fixed deposit, the customer will challenge. So therefore, it is unless both parties are agreed, the bank has no right to change the interest rate of a fixed deposit or special type of account. So I have given here another case, Foley versus Hill. In this matter, the question raised by the customer is, customer said the bank, when a customer deposit money, the bank has to pay interest for that. However, the bank generate interest by investing or lending the money that I deposit. So bank, in other words, bank take my money and invest that money in certain businesses, and they generate income. The question here raised by this customer was whether as a customer who has the ownership of the money, whether he has a right to know how much money or how much interest or how much commission or how much income the bank has generated from that money, from the money that he deposited. Then how much that they are paying to the customers as interest, how much profit the bank earned from this transaction. So those information, whether he has a right to know. So that was a question before the court in this matter, Foley versus Hill. So then what happened in this matter? The court decided like this. the money paid to the bank's bank account cease to be money of the customer. It becomes the money of the bank. So this is one thing, one important point that in this judgment, the court said, once the money is deposited to the account, it is no more the customer's money. So it becomes the money of the bank. Money of the bank. Then if it is money of the bank has the liberty or discretion to use that money as they wish. If they want, they can lend that money, or if they want, they can invest the money, or whatever the way, they can use that money to generate income. That is number 2. Number 3, bank is only answerable to the customer to repay that money together with the promised interest when the customer demand. Customer demands, the bank has to pay the money deposited by the customer together with the interest that the bank agreed to pay. That is the only liability, only duty of the bank towards the customer on deposit money. So therefore, the customer has no right to question the bank with regard to the income that they have generated from the money deposited by the customer. So this is the case, the decision of the Foley versus Hill case. So that is number 4, the customer's right number 4. Then I'll go to the next one, customer's right number 5. Customer's right number 5. The customer has a right to draw checks. The current account holders have an implied right to issue checks. Now, you know, the current accounts, as we discussed previously, as observed by the court in Chettinad versus Inland Revenue Commissioner case, current account is a unique feature of the banks or banking business, right? Only the banks are using or allowing or maintaining the current accounts for their customers. The other feature or other unique feature of the current account is the current account holders, the customers, they can issue checks from their current accounts. So that is another unique feature of this current account. The current account holders, they can issue checks. They have a right to issue checks. That is an implied right attached to the current account holder. So current accounts. You can't have a current account without a right to issue checks. So customer has a right. So you have to allow him to issue checks. You have to give him a checkbook. The customer will use the checkbooks and he can issue checks because he has a right. He has a right. On the other hand, if he has a right, what is the obligation of the bank? Obligation of the bank is bank has to accept the customer's checks and pay the checks, right? Unless there is no meaning of that right, because customer has a right to issue checks. Unless the bank has an obligation to accept the check, the bank will not honor the check. So then therefore, there is no meaning to this right unless the obligation is on the bank. The bank has an implied duty to honor the checks up to the limit of the credit balance. That is the duty of the bank. So bank has to honor the checks up to the limit of the money in the account. So if sufficient funds are available in the account, bank has to honor the customer's check up to that limit. So if sufficient funds is not available, then bank can return the customer's check, or bank has a discretion. The bank can decide to grant him an overdraft by paying the check by overdrawing the account. We call such overdraft, as we called it, as casual overdraft. Then the customer can deposit checks to his account. That is the next feature of this right. Customer can issue checks, banks has to honor the checks, and customer can deposit the checks that he received from his customers and clients. So that deposits, that's checks, bank has to accept and allow him to deposit to his account. So that those are the features of the right to draw checks of the customer. Then there is a important case with regard to the checks deposits and check payment. The case is Joachimson versus Swiss Bank Corporation. Joachimson versus Swiss Bank Corporation, 1922. It's an English case. What happened in this matter? Actually, the law with regard to the payment of the check was established by courts. The judgment says, number one, the customer has to make a demand to repay the money. When a customer, that's point number one in this judgment, important point number one. When a customer deposit money to his account, bank has an obligation to repay the money on demand to the customer, right? So the bank's right starts, or bank's obligation starts at the point the customer demand the money. If customer don't demand, the bank has no obligation to pay. So therefore, he has to make a demand. If it is a current account, that you may remember, customer has to make a demand. How he makes the demand? He has to issue a check. That is how you take money from a current account. So we are talking about classical banking, right? Not this internet banking and with ATM machines and all, right? ATM cards, but in the classical way, how you operate the account, current account, customer issue checks. Check is a demand. Check is a demand or order given by the customer to his bank. So normally, what is the order that we received as in a check? So he says this much of money amount is mentioned to pay to so and so, right? So that is an instruction. So that is a demand. So as per the Joachimson versus Swiss Bank Corporation case judgment, the customer has to make a demand, proper demand to the bank. Proper demand means if customer issue a check, that check has to be a proper valid check. Unless there is a proper valid check, the bank has no obligation to pay the check. So that is why once you receive the check, the first thing that you have to see is you have to check all the necessary parts of the check, and first you have to satisfy yourself that there is a proper demand or proper check before you, right? We are going to discuss about the bills of exchange and checks and promissory notes and so on. So then we will discuss the main features of the check. Then you can understand what are the things that you have to look into or you have to satisfy before you accept a check. So however, the point number one is the banker, you have to observe the check, and the check should be in order. Then we can say the customer has made a proper demand, right? Then the next point here, we are talking about the checks here, right? When we say the demand has to be made to the same branch. That, in other words, the customer has to make or present the check for the payment for the same branch where he maintains his account. Now, for example, we say the customer A, or Mr. Pereira, he has a current account in commercial bank at Borel branch. He issue a check, right? He issue a check. We say he has gone to Anuradhapura for a purpose, or we say journey or whatever, and he wants to take money from his current account. Now he has a checkbook, so he can write a check. We say it's a cash check, and present the check to the branch, commercial bank branch Anuradhapura, and get money. So nowadays we have Unibank computer system. So by using the system that we can even see or we can monitor or we can see any account in other branches also of the bank. So today's context, right? Even the check is presented not to the relevant branch, the banks are paying. Banks can pay because the technology has been developed. However, as per the Joachimson versus Swiss Bank Corporation case judgment, uh, as a right, if customer demand money, the customer has to present the demand or give the demand to the same branch he maintains the account. That is number one. Number two, right, that he has to make that demand to the same branch that he maintained the current account during the banking hours. During the banking hours. Now, as bankers, we have observed, you may have seen that we publish the banking hours notice in each and every branch, right? They show to the public the banking hours. It could be 8 to 10, sorry, 8 to 2 or 9 to 3 or whatever. The bank to bank, the time can be changed, time slot can be changed. However, every bank, they publish this banking hours to their customers. Why it is published? Have you ever thought about this point? Right, because it's a requirement, law requirement. What is the requirement? Customer has to make the demand to the branch during working hours. So that is number two, point number two. Now the question we comes to our mind when you see this judgment, whether the bank officers or staff can pay a check presented to another branch, not to the same branch he maintained the account. So, in other words, whether we are bound to pay. The answer is this: if it is presented, if the check is presented to another branch, not to the same branch that he maintains account, there is no obligation on the bank. There is no duty to honor the check. However, the bank can honor the check. Today, as we discussed, we have the technology. We can see the customer's account, and if the sufficient funds are available, of course, then we can pay the check from other branches also. So that is a service that we provide to the customers. That is an additional service to the customers. So he doesn't want to go to the same branch. He can operate, or rather he can present the check for the payment in any part, any branch in any part of the country. So that's an additional service that we have provided. That's number one. If bank has a discretion to pay, if you want, you pay. Right? That's number one. Number two, if it is present, if the check is presented after working hours or before working hours, not within the working hours, what is the situation? Can we pay? So as the answer is this same kind of answer. Bank, if they want, they can pay, but you are running a risk. Right? So you are supposed to pay, or you are obliged to pay, you are under duty to pay if the check is presented during banking hours. We say 9 to 3. If it is presented between 9 and 3 on a working day, the bank has to pay. Must pay. If it is presented, we say after 3 on a working day, the question is whether we can pay. or whether we should pay or must pay? The answer is it is not must but can. If you pay after working hours, the payment is legal. You can't say it is illegal. If it is illegal, then you have to return the money to the customer. However, can pay, but you are running risk. The bank is running risk. What is the risk? If you pay after working hours, if customer change the instructions or give specific instructions or stop the account, then rather stop the check. If the customer stop the check, then the bank is in a difficult situation. Now, for example, we say customer issue a check today at 3 o'clock. So knowing that the bank is closed for business for the day. So his intention is not to pay the check, right? So he issue the check and the holder brings the check after 3 o'clock and present the check to the branch. And the branch knows the customer is a good customer, so branch doesn't want to dishonor the check or return the check. So branch pay. So 4 o'clock check was paid by the bank. The next day morning, the customer gives instructions to the bank, send instructions to the bank. Stop countermand the check. Right? Early morning, you received instruction from the customer. Now what is the situation? The situation is the bank is the payment of the check. Now it is not valid. The customer has stopped the check, and therefore the bank has to return that money to the customer. So that is the danger that we run. We are running a risk when we pay a check after working hours. So therefore, it is not a customer's right to issue checks after or present check after working hours. He has no right to claim money. So that is about the judgment of Joe Kimson versus Swiss Bank Corporation. Right. So those are the duties of the rights of the customer under the banker-customer relationship. We discussed 5 rights. So if you have any questions that you can ask now, any questions? Okay. Since there are no questions, then I'll go to the next one. The next one is duties of the customer under the banker-customer relationship. Now we already discussed the rights of the customer. Now we are going to discuss the duties of the customer. Duties of the customer to the bank, towards the bank. So what are the duties that he has to fulfill to the bank? So those are the things that we are going to discuss. Number 1, the duty number 1 of the customer, duty of reasonable care. Duty of reasonable care. What does it mean? Right? Duty of reasonable care means the customer has an implied duty to exercise reasonable care when he gives written instructions or written orders to the bank. Again, the customer has a duty of reasonable care to observe when he gives instructions or when he gives written instruction or written orders to the bank, so that not to mislead the bank. So basically, in other words, the customer, in simple words, customer has no right to give misleading instructions to the bank. So he has a duty not to give misleading instructions to the bank. Or instruction which facilitate for a forgery. Instruction for facilitate forgery. So that is the other part. So customer should not give instruction which could mislead the bank, or customers should not give written instruction which could facilitate a forgery. So that is number one, the duty of reasonable care. This is very important duty cast off on the customer. This has been recognized in a case called Macmillan and Arthur, or London Stock Bank versus Macmillan and Arthur is a case. So in this judgment, it was decided like this. This case, the responsibility or the duty of the customer is known as Macmillan duty or Macmillan theory. If you get a question asking what is Macmillan theory or Macmillan duty, it is about this duty of reasonable care. I will explain what happened in this matter. In this case, this customer who is a current account holder, he issued a check. He issued a check for £2. He issued the check for £2, and you know that in the check that customer has to write the value of the check in words and also in figures. Here what happened, the customer wrote the value of the check only in figures, not in words. And also when he is writing the amount of the check, after the pounds mark, he kept a space, and then thereafter he wrote number 2. So, and this check was given to the holder. So I will explain what happened. He issued a check like this. After the pound mark, he kept a space and he put 2 here. And the amount was not written in words. So this check was given to the person. The holder took the check and he put 1 here and 0 here. Now the value of the check has altered. Initially it was £2, now it is £120. And also he wrote the value of the check, right? And the check was presented for the payment to the bank. So bank paid the check. Bank paid £120. So then thereafter the account holder realized that bank has paid more money. He intended to pay £2 only, but bank has paid £120. So that means extra £118 the bank has paid to the holder of the check. So then he filed action. Mr. Macmillan, the account holder, filed action against the bank. And his claim was that the bank has paid against the instructions of the customer. The customer's intention was to pay £2, and he issued the check for £2, but it was altered. It has been altered by the third party, so it's a material alteration. Therefore, the bank payment of £120 is illegal. So he demanded the extra payment of £118 to be returned to him. So, however, in this matter, the customer's case, he failed the case. It was decided against him in favor of the bank. Why was that? Because now when the way that he has written the check, as you know, a check is an order or instructions, or written instructions given by the customer account holder to the bank, right? So as per this principle or the duty, when a customer give instructions to the bank, he has 2 duties to observe. under the reasonable care. What is that? Number one, he should not give misleading instructions, and the number two is he should not give instruction which facilitate for a forgery. Now, the way that this customer has written the check, you see, you observe that it has facilitated for a forgery. So the holder easily altered the check, right? So the customer had been negligence at the time he issuing the checks, written instruction or written order to the bank. So therefore, it was decided the bank is not obliged to return that money, has no obligation to return the money because the customer has breached the duty of reasonable care. So that is number one. This is known as Macmillan theory or Macmillan case. The same thing that you have to remember. It's about duty of reasonable care. Then I'll go to the next one. The customer's duty. Under that, customer's duty to disclose forgeries. Customer has a duty to disclose any forgeries of his account to the bank as soon as he got to know. Right? That is number two. Duty number two. This is known as Greenwood case or Greenwood theory. Right? The related case is Greenwood versus Martin Banks that we are going to discuss the details soon. But remember, the duty is the customer has a duty to inform the bank about any forgery of his account or check as soon as he got to know. So what happened in this case? So when you when we discuss the facts of the case, then you will realize what is this duty about. Mr. Greenwood, he had a current account with this bank. So you know that when you open a current account, you get a checkbook. So he got a checkbook. Mr. Greenwood had a checkbook. He kept the checkbook at home. So after a period, when Mr. Greenwood checked his account details, that he observed that some checks issued from his checkbook had been paid by the bank. So those checks were not issued by Mr. Greenwood. He never signed those checks. So then thereafter, what he did, he checked, he investigate and he checked his checkbook and then realized that some of the checks leaf that has been taken from the book and has been filled and has been presented for the payment. So those check numbers, when he realized, has been paid. So then that means that his signature somebody has forged. So then he inquired about this from his wife. So his wife actually admitted that she forged the signature of Mr. Greenwood and took money from his account. Now there is a forgery. About the forgery, the knowledge came to the customer. However, Mr. Greenwood decided not to inform the bank. So he thought that this is my wife, and she said that I took money to help my sister who is sick. So he felt sorry about that, and whatever the reason that he thought or he decided not to inform the bank. So now that is a clear breach of duty. What is the duty? If there is a fraud on the check or on the account, at the first time that he got to know about this, he has a duty to inform the bank. So idea of this duty is to prevent further forgeries or further losses. So here what happened, he didn't inform the bank. So he said, he advised his wife to not to do it again. Then he continue his normal businesses. Then after a period, again he checked his current account statements and then realized again uh, checks have been issued from his account which were not signed by him, and someone has taken money from the account. Now Mr. Greenwood knows who takes the money, from the account. Uh, so this time he inquired from his wife. Wife admitted that she took money from the account by forging the signature. This time, Mr. Greenwood decided to inform the bank. So then, however, Mrs. Greenwood committed suicide. So after the death of Mrs. Greenwood, Mr. Greenwood filed action against the bank and claimed that bank has to return the money that has been paid to Mrs. Greenwood on forged signature checks. So he claimed that money, it has to be returned to him. So as we know, if the signature of the check is forged, the check is not valid. If the check is not valid, the payment made by the bank on the invalid checks are illegal. So therefore, the bank has an obligation to return that money to the customer. So on that basis, Mr. Greenwood filed action against the bank. However, the court decided in the other way. Court said the Mr. Greenwood has a duty as a customer towards the bank. That is to inform the bank at the first instance when he got to know about the fraud on checks or current accounts. Mr. Greenwood has failed to honor the duty. So therefore, the bank is not, the court said the bank is not obliged to return the money to Mr. Greenwood. So therefore, his case was decided against him. So that is known as the Greenwood duty or Greenwood theory or Greenwood case. So this is very important. The number two, the duty number two of the customer towards the bank. So those are the duties of the customer towards the bank, well-known duties. One is Macmillan duty and the other one is the Greenwood duty. Then the other duties of the customer's duty to check and reconcile his account. This is another important point that as bankers we should aware. The question here that whether the customer has a duty to check his account statements and to identify any wrong entries or errors in the account and reconcile the account with the bank and rectify any errors if there are as a customer, whether he has a duty. This is the question raised in this case. The case is Thai Hing Cotton Mills Limited. Thai Hing Limited versus Liu Chung Hing Bank in this case. So the decision of the case is very important. What happened in this case? This company had a current account with this bank, and the checks were issued by the authorized officer of the bank. The check were issued by the director of the bank, authorized director. However, this company, after a period of time, when they went through the account statement, they realized that there were a lot of checks being issued and realized from their account and has been paid. Those were not genuine checks. So then thereafter, the company observed that uh, uh, employee of the company has forged the signatures of the directors and has taken money from the company account. So then, as we are aware, as per the law, uh, if the check, if the signature of the check is forged, then the check is invalid. So therefore, the company sued the bank and claim the money from the bank. Money paid by the bank on this forged signature checks. The bank took the position. The bank said, in uh, uh, in our account statement, we have clearly given notice to the customer that we have said in that notice that the customer has an obligation to check his account statements and reconcile the account, and if there are any notice any error in the account, that he has to inform the bank within a reason, within the period given in that notice. Likewise, so they said there is a duty on the customer to inform any irregularities in the account statement. However, this argument or this defense was rejected by the court and said it is not the duty of the customer to reconcile his account and inform the bank. It is a duty of the bank to maintain the account in correct way. So therefore, the bank cannot impose other duties or further duties on the customer. It is the duty, if there are any irregularities in the account or any errors in the account statement, it is not the responsibility of the customer, it is the responsibility of the bank. So therefore, the customer is not bound by those statement or those um, uh, indemnity clauses that you put in the statement of account. So therefore, remember, even though you put an indemnity clause in the notice or in a notice or in a current account or savings account statements, those will not accept by courts, because the customer does not have any obligation or any duty to reconcile his account, check his account periodically, is not with the customer. So that is the case of Thai Hing Limited versus Shu Long Bank Limited Bank's case. So there are Sri Lankan cases also decided on the same principle or given the same judgment. Those are Capital Rubber Rubber Factory versus National Bank of India, one case. The other one is Collatus versus BOC Bank of Ceylon. There's another case. In these cases also, the Sri Lankan courts followed the same opinion and said the customer has no obligation to reconcile his account. It is the duty of the bank to maintain the account statement properly. So that is about the duties of the customer. Right. Then the next one, we are going to discuss about about other types of relationship between the banker, customer and the banker. Other than this, the banker customer relationship we discussed, the contractual relationship. So what are the other types of relationship that we can observe, we can see between a bank and its customers? So what types of accounts relationships that we have in the relationship between the bank and the customer can be broadly categorized into two categories, that is general relationship and special relationship. What is the general relationship? What do you mean by the general banker customer relationship? The general relationship is a debtor and creditor relationship. So general banker customer relationship is a debtor and creditor. Who is the debtor and who is the creditor? When customer open an account with the bank, if he fills in and sign the account in opening forms. By signing the form, he enters into an agreement, the contract with the bank. Then the customer, when the customer deposit money to his account, the bank become the debtor. If customer deposit money to the account, debtor is the bank, creditor is the customer, because the banks owe money to the customer. When he demands, the bank has to pay. So therefore, that you have to remember, it's a debtor creditor relationship. When the customer deposit money, debtor is the bank, creditor is the customer. Then if customer borrow money from the bank, if customer if customer get a loan or any financial facility from the bank, then this change. Then customer owe money to the bank. So then what happened? Customer become the creditor and bank become the debtor. So therefore, the general relationship that you have to remember, it's a debtor and creditor relationship. Next, we'll discuss the special types of relationship between the banker and the customer. Number one, the bank as a trustee. The trustee is the holder of the property on behalf of the beneficiary. So the customer keeps certain valuables or securities with the bank for a safekeeping or deposit, certain money for a specific purpose. The bank in such cases act as a trustee. The banks charge fees for safekeeping valuables. Now, what does it mean? Right? Sometimes we provide services to the customers. We have safety lockers facilities. So the customer, we say, customer takes safety locker facility and he brings his valuables and keep those valuables in the locker of the bank. So what is this relationship? The relationship, the bank is a trustee. Bank is holding the property or the valuables of the customer on behalf of the customer. The customer is the beneficiary. Beneficiary is the customer under this relationship. So bank is holding. So if those the goods are stolen by somebody or bank staff misuse the goods or valuables, then bank is liable for the customer as a trustee. Then bailor and bailee and bailor relationship, the other one. This you may have heard about this. This is called bailment. In the bailment, the bailment, the bailee deliver of goods by one person to another person for some purpose upon a contract. Now, between the bailor and the bailee, there is a contract. Under the contract, one party delivers the goods owned by him to the other party for a purpose. For example, we say, now take about pledge loans, right? The customer pledge his goods to the bank and take money, right? So we'll say, who is the owner of the goods? Goods are owned by the customer, and he brings the goods and keep the possession of the good with the bank for a purpose. What is the purpose? For a security or collateral to obtain a loan. So then the possession of the goods are with the bank, but bank is not the owner. Bank is holding these goods as a bailee, for the benefit of the bailor, the customer. When the purpose is accomplished, the property to be returned to the customer. Now, if customer settle the loan, if he pay everything, then the bank has to return the goods to the customer. The person delivering the good is called the bailor. The customer is the person who is delivering the goods, the possession of the good. So he is called as a bailor, and the person whom the goods are delivered is called the bailee. So the person who received the goods is the person is called bailee. In this case, the bank is the bailee who is holding the goods for the customer. The bank obtained tangible securities. In some cases, physical possession of the securities, goods, valuable bonds, etc. are taken. While taking physical possession of the securities, the bank become the bailee and the customer become the bailiff. So as I told you, in certain facilities, we take the security, we take the possession of the security into the hands of the bank. So then the bank holding that goods as a bailee, and the customer is the bailer. Once the loan is settled, the bank has to return that to the customer, to the bailer. So then the next one is lessor and lessee relationship. Lessor and lessee. Uh, when a bank lease a property, uh, a lease of property is a transfer of the right to enjoy such property for a period of time in consideration of the price paid by the by paid or promise. So now take a lease facility. In a lease facility, the property is owned by the lessor, rather lessee, right? So then, sorry, the lessor owned by the property. So he gives the possession of the property to the lessee. So lessee can enjoy the property. In return, that lessee has to pay rental or the interest or whatever the payments he has to pay to the lessor for the period that he possesses the goods, right? So then when the bank is providing a lease facility, what happened? Bank becomes the lessor and the customer become the lessee. So banks owns the property and bank lease out the property to the customer. Customer enjoy the property, we say the vehicle, right? Vehicle lease. So he use the vehicle, he rather enjoy the vehicle, and the customer pay a lease rental to the bank. So that is called lessor and lessee relationship. Then the next one, agent and the principal. Agent and the principal. What is this relationship? An agent is a person who acts for and on behalf of the principal under the express or implied authority, and the acts done within the such authority are binding on his principal. So agent and principal relationship or agency relationship is like this. Principal appoint a person called agent to act on behalf of him. So he gives authority to his agent to act on behalf of the principal. So the agent's duty is to act within the power or within the authority given by the principal. So all the transaction or all the acts done by the agent within the authority given, the principal is bound by those acts. So therefore, it's is called agency and principal agent principal relationship or agency relationship. For example, the banks we are collecting checks of the customer. So when we are collecting checks, the bank checks bills, make payment to various authorities, telephone bills, insurance premium, likewise. So we, the bank, act as the agent of the customer. So number one, right? So therefore, the whatever we do as an agent, that will abide, we will bound the customer because he is the principal. In the banker customer relationship, bank is the agent, customer is the principal. So it's a agency relationship. So that's how it works. In such cases, the bank act as an agent of the customer and charges for these services we charge for the services that we provide. Then as a custodian, the custodian is a person who acts as a as a caretaker or of something. So the banks takes legal responsibility of the customer's securities while opening an account, and banks becomes the custodian. So in other words, when a customer gives valuables to the bank for a purpose, a bank is holding that property of the customer as a custodian. So once the loan or whatever is settled, the bank has an obligation to return that good as it is to the customer, because the bank is the custodian of that goods. Then the next one, as a guarantor. Banks gives guarantees on behalf of their customers. We issue bank guarantees. So if we are issuing a bank guarantee, our role in the banker customer in that relationship, the bank act as the guarantor. So on behalf of the customer, we provide guarantees. So the banks gives guarantees on behalf of their customers, and the guarantee is a contingent contract. So it's a contract with the beneficiary of the guarantee on behalf of the customer. So that's why we call it's a guarantee is a contingent contract. We enter into with the beneficiary on behalf of the customer. So those are the special types of relationship between the banker and the customer. So next we go into the last part of this session, that is termination of banker customer relationship. So how we can terminate the banker customer relationship? Termination of banker customer relationship can happen in this way. The relationship between the banker and the customer ceased or stopped on number one, the death, insolvency, lunacy of the customer. Death of the customer, or insolvency of the customer, or if customer becomes mentally ill, lunacy, the customer banker relationship comes to it. That's number one. Number two, customer can close the account. Closing the account by the customer, which is called voluntary termination. Voluntary termination. Number three, the liquidation of a company. If a customer is a company, if company is liquidated, then the customer no more exists. So therefore, banker-customer relationship comes to it. The closing of the account by the bank after giving due notice. So as the customer, bank also can terminate the account by closing the account. So therefore, the banker-customer relationship comes to end when the bank closes the account. Then the next one, the completion of the contract or the specific transaction. For example, we say the customer and the customer maintain a fixed deposit with the bank. So fixed deposit is for a period. Once the fixed deposit is matured, if this customer has no other relationship with the bank, banker-customer relationship comes to it. That is called the completion of the contract, fixed deposit contract. So therefore, these are the methods, 5 methods the banker-customer relationship can cease or can stop. Then banker-customer relationship is a contractual relationship. It can be terminated in accordance with the terms agreed upon by the parties. If it is a fixed deposit or safe deposit, can terminate at maturity. If it is a fixed deposit, you know, at the maturity, it automatically becomes end to end. So the banker nor the customer can terminate the agreement before agreed date without the consent of the other party. So this is another thing, important thing that you have to remember. If it is a fixed deposit, bank or the customer cannot terminate the contract, the fixed deposit contract, before the agreed period. So that means, in other words, with consent, it can be terminated. Now, for example, most of the time we see when the fixed deposit is taken for a period, sometimes customers come and say that they want to withdraw the fixed deposit because some urgency. So in a situation like that, banks give consent. We charge a commission, no, we reduce the interest or whatever. Ultimately, bank give the consent. Otherwise, the customer cannot terminate the contract before the expiry uh, of the of the fixed deposit. Current accounts and savings account. What is the situation? If the customer is entitled to terminate the relationship at any given time by drawing all the funds and close the account. So customer, if it is a savings account or current account, can anytime withdraw all the money and close the account, can give instructions to close the account. So that is customer's right. So I have given here a case, a bank of Borado versus Muhammad. In this customer demanded to close the account, but bank officers didn't close the account. However, the customer then filed action against the bank. It was decided it is a breach of the duty as a banker, so therefore the customer is entitled for the damages from the bank. So that is that case. Then if banks wants to terminate the account, customer's account, what is the situation? Now we know that if customer wants to close the account, he can at any time close the account without giving any notice. But if bank wants to close the account, what is the situation? Bank can't just close the account. So that is very important. Bank has to give reasonable notice to the customer. Reasonable notice. So what is a reasonable notice? How many days or how many months that you have to give if you want to close the account of the customer? It depends on the on certain things, certain points. So it depends on the nature of the customer, the type of the customer, whether it's an individual customer, whether it's a corporate customer, whether it's a partnership. Likewise, depending on the customer. So you have to think how many dates that you have to give or how many months that you have to give notice. Reasonable notice, the date or time is not mentioned in anywhere, not in the Bills of Exchange Ordinance, not in the Banking Act, or not in any other act in that case. So therefore, the bank has to decide. So reasonable care, how many dates that you are going to give. So the number one is that it depends on the nature of the type of the customer. The next one, it depends on the type of the account that we are going to close, whether it's a fixed deposit, whether it's a current account, or whether it's a savings account. As we said, if it is a fixed deposit, unless the both parties are in agreement, no party can terminate the fixed deposit before the maturity. That is number one. If it is a savings account, the time period that bank has to give notice is less than normally when we talk about the current account. So because the savings, it's just a matter of withdrawing the funds and closing the account. So no transaction, or no checks can be issued from the savings account. So therefore, even 14 days, that means 2 weeks time, may be sufficient to close the account, close the savings account of the customer. But when it comes to a current account, it's different. That you have to give more time, a lengthy period, because the idea behind this is to you give time to the customer to make arrangements or make alternatives. Alternatives or arrangement means that the customer has to open a current account in some other bank, and he has to replace the checks that he has issued, and he has to issue new checks for those checks. He has to recall the checks and replace those checks with new checks. So therefore, for that purpose, that we have to give a reasonable notice. It could be a few months, sometimes, depending on the nature of the transaction done by the customer from his current account, and depending on the nature of the customer also. So the case here that I have given, Prosperity Limited versus Lloyd Banks Limited, yeah, the decision says the account could be closed only upon giving reasonable notice to the customer. Otherwise, bank has no right to close the account immediately. Then after termination, what happened? Banker customer relationship comes to end. But duty of secrecy extend beyond the point where the account is closed. In other words, once the duty of secrecy, once the banker customer relationship starts, the duty of secrecy starts, but it never ends. It continue even further after closing the account. Then does not affect the validity of the customer's claim in respect of the authorized debit made by the bank. So unauthorized debit made by the bank. That means if there are any unauthorized transaction done by the customer, also rather the bank just can't close the account and wash the hands. So in other words, the customer can claim the unauthorized debit from his account even after closing the account. The same principle applies to the customer. Even the customer closed the account, the bank has right to claim the dues from the customers on that account. So that is about the banker customer relationship. So we came to the end of the that topic, banker customer relationship. So if you have any questions from this topic that we discuss, that you can ask now. Okay, seems to be I can't see any questions that you have sent, not in the chat box. And you didn't ask any questions also. So then I assume that you don't have any questions. So then we'll have a break now before we go into the other topic. So after the break that we'll discuss, we will discuss the next one, next topic, that is negotiable instrument. Negotiable instrument that we are going to discuss. We'll meet in we said 20 minutes. Now it's 3:15. We'll meet at 3:35. We'll start again, the new topic. Right. So the second topic that we are going to discuss with you is negotiable instruments. Negotiable instruments. Right. We'll see. First, we'll see what do you mean by a negotiable instrument. What is the legal definition given for the word negotiable instrument? What is a negotiable instrument? It's a document contemplated by a contract. So it's a document. It's a document contemplated by a contract. Document means, as per this interpretation, it has to be a physical document. Whether we can have an electronic document is not clear, but as per the definition, per this definition, it has to be a document which is a physical document. The important thing here is this document is contemplated or created by a contract. So the parties who create the document should have a contract between them. Then this documents gives a warranty of payment of money. It gives a warranty of payment of money, which specify or describe the payee to whom the money has to be paid is described in the document. which is capable of transfer by valid negotiation of instrument. So the another important point is this document is transferable. It's capable of transfer by valid negotiation. So this is the definition given for the word negotiable instrument. Again, it's a document. The document is contemplated or created by your contract, and by this document it gives a warranty of payment of sum of money, and it describes the payee to whom the money should be paid. And the other thing, the important feature of this negotiable instrument is it is transferable. So transferable means that it can be transferred, the ownership of the instrument can be transferred to one person to another person. So these are the features of negotiable instrument. This is the interpretation given for the document, or to the word negotiable instrument. So what are the negotiable instrument known to us? There are several types of negotiable instrument, but as bankers, we are familiar with certain negotiable instrument. Those are bills of exchange, number one. Number two, we have checks and we have promissory notes. So and there are others, but the most important and most familiar negotiable instruments are for us bills of exchange, checks, and promissory notes. So out of these three negotiable instrument, the most popular or most related negotiable instrument for the bankers is checks, right? So therefore, we will, under this, we are going to discuss about the checks and bills of exchange ordinance under this lesson. We are not going to cover the promissory note part, but checks and bills of exchange that we are going to discuss. So out of that, I'll take first we'll talk about checks, because checks are more related or more relevant or more familiar to the bankers, right? So what is a check, or what is the definition given for the checks? Right? Checks is a bill of exchange drawn on a bank payable on demand. Check is a bill of exchange. So check is a bill of exchange drawn on a banker. So the drawee of the check is a bank. Drawee, drawn on a bank. Right? Payable on demand. So it is a payable on demand check, bill of exchange drawn on the bank. The check is, if we elaborate further, check is an unconditional order. Now, the bankers, you think about a check. Check, it's a document. It's a document, right? It's a document. It's a physical document. So far, so our technology and whatever, so we don't have electronic checks yet. We never knows in future what will happen, but as of today, we don't have electronic or soft checks. We have physical checks. This image clearance and all these things are there, but image means the image of the physical check. But we have not come to a situation yet to create electronic checks. The check is a physical document. It's the check is contemplated, this document is contemplated on a contract. Now check is issued by a current account holders. Current account holder issue checks. So the check is created on a contract. What is the contract? Contract is banker customer relationship contract. So who are the parties who involved in issuing of a check? The account holder, that is the customer, and the bank. Sometimes the payee also. So between the bank and the customer, the account holder, there is a contract. What is a contract? It's a banker customer relationship contract. Under the banker customer relationship contract, we know the customer has a right to issue checks. So therefore, the check is a document contemplated on a contract. So check is an unconditional order in writing, signed by the drawer, drawn on the banker to pay a sum certain in money, payable on demand in favor of a specific person or his order or in favor of the bearer. So this, you see these points and see whether this covers everything, every feature of the check. We'll see one by one. Check, it says check is an unconditional order. Now, unconditional order in writing. So check, is it in writing? Yes, it is a physical written document. Well, it says its check is an unconditional order. Is it order? Yes, it is an order issued by the customer to the bank. Customer says pay this much money to this one. So it is an order. So it says, further says it's an unconditional order. Unconditional order means you can't put qualifications or you can't put the drawer, the account holder can't put conditions. So you can't put a condition like say like this, pay 1,000 rupees if this happens or something, yeah, some condition. If we'll say a simple example, we say if a profit earn pay $1,000, 1,000 rupees, right? So it's a condition. There is a condition. It's a conditional order. So therefore, the check is not valid. So in a check, it is an order given by the customer, that account holder, to the bank. However, it is an unconditional order. You can't put conditions. Then the check is signed by the drawer. Who is the drawer of the check? Drawer is the account holder. So if it is a valid check, you know, every valid check has to be signed by the drawer account holder. If the signature is not there, or if the signature is forged, check is not valid. So therefore, that point is also correct. Then the check is drawn on the banker. In other words, the drawee, the person who has to make the payment, is the bank always. Yes, that is also correct. You see, in a check is issued to a bank. You can't issue a check to some finance company, because finance companies are not supposed to maintain current accounts. So therefore, in a check, the drawee always is a bank. That point also then correct. Then the next point, to pay a sum certain in money. So what is the order given in a check? You see, it says pay 100 rupees or pay 1,000 rupees or whatever the amount certain in money. So order to pay. Order to pay. So that point also you observe that you have to, when you are writing a check, that you have to mention the amount in certain. You can't put a uncertain amount like pay the profit or pay the interest, right? So then you can't consider that check as a valid check, because the amount mentioned in the check is not certain, right? So therefore, the amount in the check has to be written in certain in money. Then check is payable on demand. Is that correct? When the check is presented to the payment, presented for the payment to the bank, bank has to pay. You can't postpone. It is on demand document. So on demand payable document. Right. Next one, in favor of a specific person, or to his order, or in favor of the bearer. Now, what is that? A check can be written in favor of a person. For example, pay 1,000 rupees, then you put the name of the payee, the person who received the money. You put, we say, Nimal Pereira. So a specific person. Or you can put Nimal Pereira or his order. So that is another way that you can write a check. Or you can issue a cash check. without putting a name of the payee. So then it becomes a bearer check. Bearer check means any bearer can obtain the value of the check by producing the check to the bank. So all these points mentioned here, you can see, you can observe, should be in a check if the check is a valid check. So that is that those are the features that are very important in a check. Next, we'll see what is the law applicable to the checks, or what is the law govern checks. Right, checks and bills of exchange both are governed by Bills of Exchange Ordinance number 25 of 1927. You have to remember this. This is very important, and you can't score marks unless you write the correct the act or the ordinance with the number and the year. Right, checks and bills of exchange both are governed by Bills of Exchange Ordinance, not by the Banking Act or not by any other act. Those are governed by Bills of Exchange Ordinance. Bills of Exchange Ordinance. There's no separate law for the choice for checks in Sri Lanka. Or in other words, with regard to checks, there is no other statutory law passed by the Parliament. Only the statute passed by the legislature is the ordinance, that is the Bills of Exchange Ordinance, which govern the law, or which applicable to the bills of exchange and as well as checks. Then check has a dual aspect. Check has a dual aspect. What is a dual? What do you mean by dual aspect? Anyone has a question? Okay, right. Right. Then what is the, what do you mean by dual aspect of the check? Right. It is subject to the Bills of Exchange Ordinance and it is considered as a negotiable instrument. On one side, check is a negotiable instrument and it is subject to the Bills of Exchange Ordinance. So therefore, one aspect is check is a negotiable instrument. The other aspect of the check is it is a mandate or instruction issued by the customer to the bank to pay amount stated on or after the date mentioned there. So in other words, check has a dual aspect. One side, it is one hand, it is a instrument, negotiable instrument. On the other hand, it is a mandate or instruction, written instruction given to the bank from the customer. So those are the 12 aspects of the check. Then the next question is whether the printed check forms is necessary to use, or whether it is mandatory to use check forms, printed check forms issued by the bank to issue checks. As per the practice bank, as per practice, banks issues printed check books to the customers. At the time of opening the account, the customers agree to use only the printed check forms. Now remember this. As per the Bills of Exchange Ordinance, using of printed check form is not a requirement. Again, I'm telling, as per the Bills of Exchange Ordinance, using of printed check forms is not a necessary requirement. So therefore, in other words, the people and the customers can use their own format to issue checks. Now, what is the practice? In practice, we never allow the customer to use their own format or own printed check forms. The banks provide checkbooks to their customers, current account holders. So at the beginning, at the time of opening the account with the customer, we have an agreement. What is the agreement? We say you have to use the checks check formats or check leaves that we provide to you to issue checks. Otherwise, your checks that we will not accept, right? So therefore, we have agreement with the customer, and a customer is bound by the agreement to follow or to issue checks by using the checks formats, printed check formats that we provided to the customer. So a customer who has more than one current account cannot use checks from forms issue by one account to issue checks from the other account. So we say a single customer has more than one accounts, right? Current accounts. We say current account number 1 and current account number 2. This customer, so as we know, the check, we give 2 books, checks books to the customer from each account. But the customer cannot use one check leaves to issue a check from the other account. For example, we say that his current account is checkbook for current account number 1 is over, but he has the checkbook issued to the other account. So basically, he can't take a check leaf from the second checkbook, which is related to the second account, and just cut the account number and put the account number. No, it's not possible. So it is not a practice in the banking. So the customer has agreed, and the practice of the bank also is to issue checks in the given format by the bank. So that practice now has become and has been accepted in court of law as a banking law. So initially, the important thing here is that it is not in the bills of exchange ordinance. However, this practice later on has developed by the bankers, and which has been now accepted by the courts. Now it has become a part of the banking law, or in other words, it has become a part of check law in the country. Not only in the country, but it is a well established practice and also well recognized law principle all over the world. That is about the check formats. Now we'll see. I have given here a picture of a check, real check. So you can see in this check there are important features or points that I have marked 1 to 7. So what is number 1? 1, you can see the name of the bank, right? Name of the bank means where the customer maintains his current account in this bank. What is that bank in this check? It's First Bank of VIKI, right? This is the drawee. Drawee is the bank who is supposed to pay the money. That is number 1. Number 2, it says pay Wikimedia Foundation. So the person who received the money is Wikimedia Foundation as per this check. So that is the payee. Payee is the person who received the value of the check. Then number 3, you can see the date of the check. Date of the issuance of the issue day of the check. It's mentioned there, right? You can see it dated as 22nd January 2006. Then number 4, you can see the amount of the value of the check. Here you can see the amount or the value of the check has been written in words and also in figures. 100 pounds in words and also in figures also it has written. Then number 5 is the name of the drawer. Name of the drawer, that is drawer is the account holder. And the number 6 is very important. That is a signature of the drawer. Signature of the drawer. So which is very important. We'll discuss why it is important. Then you can see there are numbers, 3 numbers mentioned in the bottom line of the check. Number 7 that I have marked, it entire row is called magnetic in characters, right? But there are three numbers. In the left hand corner, the check number is given. Check number is very important. Then you can see there the middle series of number which says branch sort code. Then the third one, the right hand side number indicate the account number. So if I ask which number is important in a check, it is the check number. Check number is the most important number. So other two numbers are not essential and it is not relevant to the validity of the check. So branch sort code and the account number is there for the purpose of the bank, or to easy the work of the bank. So we want to identify the check number, rather the account number and branch sort code. Then that is easy purpose of the bank, not relevant to the customer. The relevancy of the check number is very, very crucial, because that how we identify the check. For example, we say now Mr. Jones, who is the current the account holder in this check, would have issued many checks. But if we give countermand instructions, he have to specifically mention what check is that he has stopped. How he mentioned? By the check number and the date and the value. So check number is very important when it comes to come to the features of a check. So these are the most important material features of a check, right? So then we'll go to the next one. Now one by one we will discuss the law relates to checks, right? Number one, the check must be in writing. The principle, the law principle is the check must be in writing. When we say in writing, what do you mean by in writing? Can you print the check? Can you write a check by using ink pen, or can you fill the check by using a pencil? So these are some matters that we have to consider, we have to discuss and see whether those methods are legally acceptable. So ideally, the check should be written in ink or typewritten. So in other words, when you take this check, then you can fill the blanks in this check format by using ink pen. When we say ink pen, that is including ballpoint, carbon ballpoint pen, or any type of pen you can use. That is one method. However, it has to be a pen. Then the other method is you can typewrite also. So when we say typewrite, it could be electronic typewriter, or it could be a manual typewriter, or even sometimes it could be a computer for the purpose of typing. Right, so the method is that. So, right. So, what about a check written or filled by using a pencil? Can we accept? The question is that answer may be accepted. May be accepted mean the check written by using a pencil is not illegal, or it is, in other words, valid. It is valid. May be accepted means, right? It's the discretion of the bank. It's a discretion of the bank. But if there is a reason, what is the condition? If there is a reason to suspect, the bank should not pay. That is very important. If it is a pencil written check, bank has a discretion. Bank can accept the check because it is valid in law. However, the bank has a duty. If there is a reason to suspect, the bank should not pay such check without confirmation from the drawer. So that is very important. If it is a pencil written check, best thing, either you have to return the check, or you pay after getting a confirmation from the drawer, the account holder. Drawer could be a third party. The drawer should be the account holder of the bank, right? So therefore, you have to get the account holder's confirmation, the drawer's confirmation before you pay. Pay could be a third party or whatever, but you have to get the confirmation from the account holder if it is a pencil written check. Then what about the printed check forms? We discussed that the bank refused to honor the check which is not drawn on a printed check form. The bank should give reasonable notice to the customer. In other words, customers can use their own check formats unless the bank has informed the customer or has a separate agreement with the customer to follow or to write checks on the given printed check forms. So that we have already discussed. So that is the the view regarding the printed check forms. Then signature of the drawer. Signature of the drawer. Check. Is it very important? Is it a material feature of a check? Signature of the drawer. The check has to be signed by the drawer personally or by the authorized signatory. Signature of the drawer is very important feature of the check. Check is not legally valid unless it is signed by the drawer. When we say the signed by the drawer, it can be signed by the drawer personally or signed by the authorized signatory. Now, for example, if it is an individual account holder, a natural person, he personally can sign the account, sign the check. Or he can appoint an agent. So by power of attorney, he can appoint an agent. The power of attorney holder then can sign, issue checks. Or if it is a corporate customer, a company, then the company can nominate authorized signatory. You know, the company, when we say the company or corporate entity, that entity is not a natural person. It's not a live person, right? So it is just a legal body. So that legal entity has to work, has to appoint a natural person as the agent to carry out the businesses. So the company can authorize a staff member or director of that particular company to maintain and operate the account. So that person is called authorized signatory. So the authorized signatory on behalf of the company, corporate, the customer can sign the check, which is then valid, can be considered as a valid signature of that company. Then can be signed in ink, in pencil, or mechanically, or by rubber stamp. Again, how you are going to sign? What type of equipment or pen that you have to use, right? It can be signed by ink, that means by using a pen, or by pencil, that we already discussed, by pencil, or mechanically. Mechanically means you may have seen sometimes the checks we print with the signature of the drawer. Example, the checks issued for the shareholders as dividend of a company. So those checks are printed with the signature of the authorized signatory of that particular company. So that is another way, mechanically sign document, sign check. Then by using a rubber stamp, you may have seen, sometimes you may have seen this also. Instead of signing the check, they put a rubber seal, only the rubber seal, there's no signature. Now for example, the law firms, accounting firms, audit firms, they use these rubber stamps signatures. For example, Pereira Associates. So that is we say it's a accounting firm, right? So they sign their checks as Pereira Associates. So sometimes they write that in ink, or sometimes they use that a rubber seal and put that that signature on the check. So both are acceptable under the law. So that how you have to sign the check. Then the most important point, you can't typewrite the signature on a check. That is not acceptable. Basically, you can't typewrite in the signature space, that you can't typewrite. Pereira Associates typewritten is not acceptable. Either you have to write it or you have to place a stamp duty there. Then the signature can be a fiction name or even trade name. So what do you mean by fiction name? Fiction name means if it is a if it is a natural person, we take a natural person, we say Nimal Pereira, right? Nimal Pereira uh, uh, is a natural person. When he is signing, it is not necessary to sign his name. So in other words, Nimal Pereira can sign as Kamal Pereira. So or without any name, he can put a mark, right? Some symbol, something. So which he can use as his signature. It is not necessary to sign his name. It could be a fiction name, it could be a mark, or it could be a any symbol or anything. What requires here is he has to place his signature by using ink, pencil, or mechanically or rubber stamp. So that is one important point. The other important point is it can be signed. A signature can be a trademark also, as I informed you previously. So example, we take audit firm, right? Nimal Pereira Associates. That is the firm, the name of the firm, audit firm, business name, trade name. So that can be used as a signature for the purpose of the issuing check. In the check, they can sign as Nimal Pereira Associates. So that is also possible. Then a company check can be signed by the agent of the company or authorized officer of the company. That already we discussed. The company is not a natural person. It's a legal entity. So the legal entity has to appoint an agent or authorized signatory to operate the account and issue checks. So that person, authorized person, can issue checks on behalf of the company. Then the check is signed in the name of the partnership. Each partner is liable on the check. So once the check is signed on the name of the partnership, if the account holder is a partnership, if one partner signed the check on behalf of the partnership, all the partners are liable on the check. All the partners are liable, even though the other partners have not signed the check, they are also liable because it is a partnership, right? That is about the signature of the drawer. Signature of the drawer. Next, what is a specimen signature? What is a specimen signature? So we bank in the banks, when we are opening account, especially the current accounts, we take customer specimen signature. Specimen signature. Why we take a specimen signature? What is the reason? Right? Specimen signature is given in the mandate or signature card. So at the account opening point, we take the customer signature on the mandate form, or we have a separate card which is called signature card. We ask the customer to sign in that card. And nowadays what we do, we scan that signature and feed into the system. So then after that, after feeding that into the to the system, that we can observe, and when the check comes, what we do, we compare the signature in the system or in the specimen signature card with the signature in the check or in instruction, and compare, and if you are satisfied the signature is same, then we consider that is a check issued by the same account holder or instruction given by that account holder. So then we act according to the instruction given by the account holder. So specimen signature is very important to have to identify or recognize the instructions of the customer, whether the instructions has been instruction have been given by the customer or somebody else. How do you decide that you decide after comparing the signature of the specimen card or signature card and the particular document. So the signatures of the check should be in should be confirmed with the specimen signature. If not, the banker should refer the checks to the drawer or return the check with the remark signature differs. If the signature of the check is not in accordance with the signature in the signature card or the system, so what you have to do, you can't pay the check because the signature is differ. Then you have to return the check. How do you return the check? You have to return the check, return to the drawer, or return the check with the remarks signature differs. So this is very important. When it comes to signature, specimen signature is important to identify the instructions of the customer. Then if the customer is illiterate, that means he is not a person who can write letters. So then what is the situation if he can't write? So then that person, that customer can be signed by a mark. As I told you before, it is not necessary to write the name as a signature. So any mark or any symbol or anything can be considered as a signature. So therefore, that person who is illiterate, who can't write letters, can use a symbol or mark as his signature, as long as he can draw the signature in the checkbook. That is more than enough. So it is a valid signature then. Such a signature should be witnessed by a banker. So that signature the customer has to place before before uh, before the banker and another witness known to the banker. So he has to sign the check before using a mark before two people, that is the banker and also with another witness known to the banker. Now sometimes things like something like this can happen. Now a person uh, who actually was a normal person at the time of opening the account, later he is now incapable of signing because we say he has a Parkinson's disease or whatever. So in a situation like that, what do you do? There are two ways that you can act. One is that person can go to courts and uh, 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 get a court order to withdraw the money from the account, uh, or he can then use a signature like this and operate the account. These possibilities are there. So then if a customer is too ill to sign the check, so what is the situation? Then in a situation like that, the customer can sign by a mark again because he can't use his normal signature because he is too ill. Then that signature must be witnessed by the customer's doctor and another witness. Two witnesses has to testify the signature. So who are they? That is the doctor and another witness. And not only that, there is another requirement. Doctor has to give a certificate with regard to the signature and his illness. So using uh, by obtaining those two things, that is the witnesses and also the doctor's certificate, that we can accept the instruction of the customer and pay the check. So those are also very important. Then we'll go to the next one. If the drawer's signature is forged, this is very important. This is very important. If the signature the of the drawer is forged, what is the situation? Then the law is very clear. If the check, the signature of the drawer is forged, the check is void. Void means it is not valid. Check is not valid. Check is not valid if the signature is forged. You can't say that the signature has been forged very cleverly and the signature uh, in the check and in the specimen signature is more similar, and you can't find any difference between these two, which so cleverly forged, so therefore it is valid. No, it is not the case. If the check has been signed by any other person other than the drawer, the check, then the signature is forged. Basically, if I am the account holder, I have to place my signature. I have to place my signature, right? We said I have a friend who can sign my signature better than me, right? Better than me. So he can, there are people, like skilled people like that, right? So he can sign my signature, right? In my absence, he take my check leaf and he signed my signature, right? He signed my signature, he pastes my signature on the checkbook and produce that check for the payment to the bank. What is the situation? So it's very clear. Since I have not signed the check, it is not my signature, it is a forged signature, check is then invalid. So therefore, bank cannot pay. Bank cannot pay. When there is when there is no check, you can't pay. If there is a valid check only, bank can pay. Right? Now, when the check is presented, the banker will not observe any different. Right? So then the bank, there is a chance that bank pay the check without observing the check is forged. However, law is very clear. Even though bank cannot observe any difference between the signature and the forged signature, bank cannot make the payment for the forged signature check. So if the bank pays, that money has to return to the account holder because the check is not valid. The banker has no right to debit the customer's account. If the check is paid by the bank, the account holder has a right to claim the money from the bank. So you have paid money to a third party, but ultimately it appears that the check has been signed by somebody else, not by the customer. Then the customer comes and demand the money. Bank has to pay the money to the customer. You can't say that we can't observe any difference, so we paid to a third party, so therefore you go behind him and take the money. No, that is not the case. Bank immediately has to return the money to the customer, account holder. So we have to go behind the person who got the money, third party, and recover the money from him. It is not the customer who has to go behind that person, right? That is the law. So then if the forgery comes to the knowledge of the drawer, he has a duty to inform the bank ASAP. So in the situation is, we discussed this previously also, that is Greenwood, under the Greenwood duty. If customer knows that the signature has been forged, he has a duty to inform the bank to prevent the fraud. The customer just can't wait and see. And if banks pay that, he can't come and say that my signature was forged. I knew that, but you have paid, now return my money. That is not possible, because if he has the knowledge of forgery, he has a duty to inform the bank at the first instance. So therefore, that is his duty. He is in breach of duty. So therefore, he can't claim the money from the bank. Right. Then section 24 of the Bills of Exchange Ordinance, very important that you have to remember the sections also without writing the section. If you just write the low part, that you won't get full marks. So therefore, it's very important to remember this section 24 of the Bills of Exchange Ordinance number 25 of 1927. So section 24 says, where the signature of the check is forged, the check is wholly inoperative. Wholly inoperative. That means it is not partly valid, right? Signature is forged. The check, entire check is invalid. No one can argue that part of the check is valid, the other part is invalid. Nothing. It's the check is not valid from the beginning. Or in other words, there is no check. There is no check. If there is no check, bank cannot pay. Simple as that. So important case, there's an important case decided in Sri Lankan courts, that is Bank of Ceylon versus Kolonnava Urban Council, decided in 1951. In this case, it was held that section 24 does not permit the bank to debit any account if the signature is forged. So as per the section 24, bank has no chance to debit the customer's account if the signature is forged. The customer's negligence is immaterial. So you can't say that because you are negligent that that thing happens. So therefore, we are not liable. That is not material. Customer's negligence is not material. If the signature is forged, there's no chance that bank has to return the money. That was the decision in the Bank of Ceylon versus Kolonnava Urban Council Urban Council 1951 matter. What happened in this case? The clerk of the Urban Council has forged the signature of the authorized signatory of the council and has taken money from the council account. So this was observed by the council after a period of time. By that time, this person has taken a lot of money from the account, and the council filed action against the Bank of Ceylon. So their position was the signature of the signatory has been forged by another person. So therefore, the bank has no right to debit the account. Bank has debited the account, has paid the money. So therefore, they demanded the money that they paid, the bank paid for the forged signatures check. So the section 24 of the Bills of Exchange Ordinance is very clear on that matter, which says if the signature is forged, the whole check is not valid. So the council was relying on this section. So in answering to that, the Bank of Ceylon's position was the council was negligence because they just kept the checkbooks unattended. Therefore, any officer of the any person from the of council could have taken check leaves. So they are thereby the council has acted negligently. So that was their defense. However, court rejected that defense and said the negligence of the account holder is not relevant. The section is very clear. Section 24 says if the signature is forged, then that check is wholly inoperative. So therefore, the customer is entitled to get the money. So that is section 24 of the Bills of Exchange Ordinance. Then we'll go to the other feature of the check, the amount of the check. Amount of the check. So amount of the check should be mentioned in words and figures of the check. This is a legal requirement, and also in the practice, amount we have to write in figures and also in words. That is a requirement. So what happens if there is a discrepancy between these two? This could happen, right? When we are writing the check, sometimes you observe there's a discrepancy between these two. Now, for example, we say in written words, it says 1,000 rupees. 1,000 rupees. In words, the amount has written as 1,000 rupees. But in figures, uh, there is an extra zero, so therefore it looks as a the amount mentioned in figures says 10,000 rupees. Now there's a discrepancy. There's a discrepancy between the values mentioned in words and mentioned in figures. Now what do? What amount you are going to pay? Is it 10,000 or is it 1,000? Or what is the basis? If it is 1,000 or 10,000, what is the basis that we pay? So answer is this: the bank could seek confirmation of the drawer. So in a situation like that, it's best thing, don't pay any amount, 1,000 or 10,000. So best thing is to get a confirmation from the drawer. So if drawer says pay 1,000, so that then the confirmation is that you pay. Or if drawer says it's 10,000, so on the confirmation of the drawer we pay. Or the other method is that the banker could dishonor the check with the remark. So if you can't contact the drawer, right? So what is the situation? Then you can't get a confirmation. So if you can't get a confirmation, there is an option to the bank. The option is that you can return the check, dishonor the check. What is the narration or what is the dishonor note that you put in the check? You can't put refer to drawer. That is wrong. Refer to drawer means there's no sufficient funds in the account. It is not the case. So therefore, you have to put the correct narration or correct remarks on the check. So what is the remark that you're going to put? That you can say amount in words and figures are different. So that or differ, that you can say. You can write on the check. Or amount required in words. These two that we use, these two narrations or these two remarks, we use when we are dishonoring the check due to a discrepancy in the amount in written in words and in figures. So then payment on demand. Payment on demand. We said the check is payment on demand. So that, in other words, when a valid check is presented for the payment, so bank has to pay the check on demand. That means then and there you have to pay. Can't postpone the payment. So check is payable on demand. It is not compulsory or necessary to include the words on demand or on site, at site, or presentation. When you are writing a check, you don't write pay 10,000 rupees on demand, or you don't write pay 10,000 rupees at site, or you don't write pay 10,000 rupees on presentation. Those words we don't write. It is not necessary to mention. Even though it is not mentioned, the check is payable on demand. That is the accepted law, accepted norm with regard to the checks. So when the check has to be drawn in same currency in which the account was opened. That's another important point that you have to remember. If it is a rupee account, you can issue checks. If it is a rupee current account, that you can issue checks only of the value rupee value, only with the value of rupee value. If it is, you can't issue checks with the value of other currencies. Now, for example, if you have a rupee account, you can't issue a $10 check, right? You have to write the check, the value of the check in rupees, right? If it is a dollar account, you can't issue a rupee value check. So that is what meant by this. The check has to be drawn in the same currency in which the account was open and maintained. The customers are permitted to issue checks on foreign currency accounts subject to foreign exchange laws. So the customers who are maintaining foreign currency accounts, they have been permitted with limitations, that they can issue foreign currency checks from foreign currency accounts subject to foreign exchange laws. So the foreign exchange laws will apply for the foreign currency accounts. That then we'll go to the other one, order checks and bearer checks. Order checks and bearer checks. What is order check and what is a bearer check? Order check means a check drawn to a specific person or to the order of a specific person. We know in the check that we mention the payee. We mention the payee. Payee is the person who received the funds of the check. Who received the funds of the check. So now, in a check, we can mention the payee's name. By personal name we can mention, or we can mention the person's name or his order, like this, right? We can say, we can draw a check, pay 1,000 rupees, pay Nimal 1,000 rupees, right? Or we can say pay Nimal or order 1,000 rupees. So that type of check we call order checks. Order checks. Then bearer checks. The other type is bearer check. What is bearer check? Bearer check is payable to the bearer. A check drawn in favor of a person in position of the time being using the word such as pay bearer is known as the bearer check. That means in the place that you have to write the name of the payee, you write the word pay bearer. Without putting a name, a personal name, you put bearer, or you can put pay cash. So both are bearer checks. Bearer check means the person who bears the check can produce the check for the payment and he can take the money. So he becomes the true owner of the check when he holds the check. So that is the difference between the order check and a bearer check. Then a date of the check. It's another important point that we discuss. Another important feature of a check, the date. The check is not invalid by reason that it is undated. This is very important point. For example, we say the customer has issued the check. The customer, in the sense the drawer, the account holder, has issued a check without putting a date. So it is undated then, undated check. The question is whether it is valid or not. Now think a situation like this. Customer has issued a check without the signature, the drawer's signature. Now the question is whether it is valid or not. It is not valid. So check is not valid without the signature. It is not a check. Customer or a check, not the customers, a check has been issued with a forged signature. So that means the drawer's signatures someone has forged. Then what is the situation? Legal situation? Check is not valid. The legal position is that. Now a check has been issued by the customer. So all other features are there, but it is undated. He has purposely or by an oversight, he has not put the date. So the question is whether the check is valid, right? Check is valid. So remember, the check is not, it's valid even though it is undated. So the important point is you can't present the check without a date for the payment. So when you are presenting the check, bearer has to insert a date and present for the payment. So if it is presented with the date check with a date, that date will be considered as the issuer's date and the bank can accept the check. So check, when we are dating a check, when you are putting a date on the check, there are ways that we can put the date. So what are the ways that we can, or what are the methods that we can use to put a date on the check? So we can put, there are checks dated in three ways. One is dated. Dated means that when the check is issued, there are three ways, that is dated, antedated, and post-dated. Dated means you issue a check today and the drawer put the date as it is. So for example, today's date, right? Today's date, we say today is 11th of July and I am issuing a check today and I put the date as 11th of July 2021. So the issuance date of the check is the 11th of July, the same day that I sign and issue the check. That is one method, that is called dated checks. Then the other one is antedated check. Antedated check means antedated in the sense in future date. Sorry, a past day. It's a date passed by now, right? Antedated means that I issue a check today, 11th of July 2021, and I put a date as 1st June 2021. So check is valid. It's a past date. The issuance date is considered as the 1st of June 2021. So the validity period of the check will be starting counting from the date appears on the check. So that is the difference. Then there is another type of checks which is called post-dated checks. Post-dated checks. What is post-dated check? Post-dated check means the date of the check is a future date. The example is, say I am issuing a check today, 11th of July 2021, but I put a date I put a future date on the checkbook. Example, 31st December 2021. So the date has not come yet, but I put that date today. So it is a post-dated check. So the check is valid for another 6 months from 31st December 2021. So that is the difference. So these three types that you have to remember: dated checks, antedated checks, and post-dated checks. What is the situation if a post-dated check is presented for the payment? Post-dated check means the date is a future date. Now what about the other two? If it is a dated check, if it is presented, if the check is not stale, bank can pay. What do you mean by stale? Stale means there is a validity period for a check. In Sri Lanka, the validity period of the check is for 6 months from the date on the check. So if it is a dated check, that means if I issue a check today with the date 11th July 2021, that check is valid for another 6 months from today. So if the check is presented during this period before the expiry, the bank can pay. The other one is antedated check, which carries a past date for the payment. So we say now the check is presented for the payment and it carries a date, we say 1st of June 2021. So from 1st of June 2021, the check is valid for another 6 months. Right? If it is presented today, now the one month has gone, 1.5 months gone, but check is still valid. It's not stale. It's valid. So therefore, bank can pay. Right? That is number 2. Number 3, post-dated check. Post-dated check, the date is mentioned as 31st December 2021. And if it is presented for the payment tomorrow, what will happen? So then what is the situation? If a post-dated check is presented for the payment before the date, it should be returned with the remarks of post-dated. So basically, bank should not pay a post-dated check before the date, before the due date, before the issuance date. You can't pay. So if the bank pays the post-dated check, what will happen? Whatever the reason, maybe by mistake or by whatever the reason, bank without observing or without after observing, bank pay the post-dated check before the due date. So then what is the situation? What is the stance? What is the law? So the banks pays the post-dated check before it due. The bank has to bear the loss or damages that could arise out of the transaction. Otherwise, the payment is legal. So what is the situation if it is paid before the due date? Bank is taking a risk. Bank has taken a risk, but because the drawer can anytime before the due date that he can uh, countermand the payment. So if that happened, what is the situation? So the bank by that time has paid the check. So bank has to bear the loss. Bank has to return the money to the account holder, and bank has to bear the loss. That is the danger when you are paying a post-dated check before the due date. So the best practice is to return the check if it is a post-dated check with the remark post-dated. So that is about the date of the check. Then negotiation of check. So check is a negotiable instrument. As we discussed, it is a negotiable instrument. Check can be negotiated by transferring from one person to another person. That since it is a negotiable instrument, check can be negotiated from transferring the check from one person to another person. So section 31 of the Bills of Exchange Ordinance says a check payable to the bearer can be negotiated by delivering the check. Now the negotiation of check, you have to understand very carefully. You have to pay attention because of the negotiation, the method of negotiation of a check change with the type of the check, right? So if it is a bearer check, what is the situation? How do you negotiate? If it is a bearer check means that anyone who bears the check can encash the check. Okay, can get the money. It's like money. It's good as money, right? For example, we say now if you have 1,000 rupees in your hand, if you want to negotiate that 1,000 rupees, how do you negotiate? If you want to give that money to somebody else, how do you do? So you just give that 1,000 rupees to the other party. So he get the money, so he get the value. So if he want to negotiate to another person, so what he has to do is he has to just give that money to the note, 1,000 rupee note, to somebody else. So then the next person will get the ownership of the or the value of the note, money note. So likewise, if it is if the check is bearer check, so that can be negotiated by just handing over the possession or by giving or delivering the physical check to the other party. So that is the way to negotiate. So the new person to get the check, physical check, get the right to encash the check. So he can produce the check to the bank and get the value, or he can negotiate that check to somebody else. So that is the way that we have to, the method that we can negotiate a bearer check. So then what happen if it is an order check? So order check means that the payee's name is mentioned on the check, right? The payee's name is mentioned. So pay Nimal Pereira 1,000 rupees. That's how we write. So now when we see this bearer check, this payable order check, the payee only can take money, right? If it is a order check which is written in favor of Nimal Pereira, if that check is lost and found by somebody else, Saman Pereira can't bring the check and give to the bank and get the money. because it's an order check. But if it is a cash check or bearer check, if the if that person miss if the bearer lost the check, if somebody found the check, he can bring and get the money. So negotiation of order check is different from the negotiation of bearer check. So how do you then negotiate order check? So negotiation by endorsement of the holder and complete by the delivery of the physical check. So there are two parts in this negotiation of order check. So there are two requirements. One is endorsement. Endorsement means of the back side or the behind of the check, the rear side of the check, the payee has to endorse. Endorse means that he has to sign his name in the back side of the check. That is called endorsement. Endorsement. So that is number one. So after endorsement, it has to be negotiated by delivering to the other party. That means the physically that you have to hand over the check, the endorsed check. So that's how we negotiate a order check. So there are two types of negotiation depending on the nature of the check, whether it's a bearer check or whether it's a order check. So these two that you have to remember how to negotiate a check. Then endorsement. Endorsement, I said endorsement is necessary to negotiate an order check. So order check you can't just negotiate. You have to endorse the payee has to endorse and then negotiate or hand over the check to complete the negotiation. So there are three types of endorsement that you or the payee can place. That is blank endorsement, number one. Number two, special endorsement. Number three, restrictive endorsement. There are three types of endorsement: blank endorsement, special endorsement, and restrictive endorsement. When you say the blank endorsement, what do you mean by blank endorsement? Blank endorsement means endorsement which does not specify any endorsee. So that means the payee sign the backside of the check without mentioning any name of the endorsees. So it's just a signature. So what will happen? It is called blank endorsement. Once the blank endorsement is placed, or just signature of the payee is placed, that check become a bearer check. That check becomes a bearer check because that check then it's without mentioning any endorsee's name. It's like a cash check. So anyone who holds the check can encash the check, can get the money. So that is called blank endorsement. Number two, the special endorsement. Special endorsement is different from the blank endorsement because in this situation, the endorsement specify the endorsee. So basically, when you are when the payee is signing the backside of the check, he's mentioned the name. Endorsee's name, right? So then what will happen? It again still it becomes a order check, right? So you Nimal Pereira, we say the initially the payee of the check is Nimal Pereira. He want to negotiate the bill or the checks to Sumal Pereira. So what he has to do is he just can't give the check to Sumal Pereira because it is an order check. Then the Sumal Pereira will not be able to get the money for the check. So therefore, Nimal Pereira has to negotiate the check. So there are two requirements now. Firstly, he has to negotiate. He has to endorse the check. So he can put a special endorsement. So how do you put how he can put a special endorsement? He has to sign. Nimal Pereira has to sign the backside of the check. That's number one. And if it is a special endorsement, he can put a endorse his name. So he can put the name pay Sumal Pereira or order. Now what is the situation? He has introduced a new payee who is called endorsee. So now still the check is now still it is an order check. So it will you can then thereafter hand over the check to Sumal Pereira. Then Sumal Pereira becomes the bearer and also the endorsee. It's special with the special endorsement. So now Sumal Pereira can produce the check to the bank and get the value of the check. So still the check is a order check. That is number 2. Then restrictive endorsement. Restrictive endorsement is this: a check or a check bears an endorsement which prohibits the further negotiation or transfer of the ownership. So when a payee or bearer endorsing the check, that he can put a restriction on the negotiation. So then thereafter what will happen? The check by putting a restrictive endorsement, we can restrict the negotiation or transferability of the check thereafter. So therefore, then the check cannot be negotiated further. So those are the 3 types of endorsement that we can use to endorse order check and order check for the purpose of negotiation. Right. Right. Next, we are going to discuss about the cross checks. Now, what is the crossing? What do you mean by crossing? Cross checks. Crossing means, as per the Bills of Exchange Ordinance, crossing means draw 2 before that we can classify the check into 2 categories again, that is open checks and cross checks. Open checks means the bank, if it is an open check, if it is not crossed, the bank is obliged to pay the amount stated on the open check over the counter. So if it is not crossed, the bank can pay the check open counter on over the counter to the order or to the bearer, depending on the nature of the check. So if it is a cross check, then it changed. So then what happened? The bank cannot pay the cross check over the counter. That is the change or the significant feature of the crossing. You can't pay, the bank cannot pay the check over the counter. It has to be cleared through an account. So in that on other way, if I say the cross check you can't pay over the counter, it has to be deposited to an account and the clearance should be go through that particular account. So that is the difference between the open check and cross check. Now we'll see what you mean by crossing. Right? Crossing. Bills of Exchange Ordinance section 76 talk about the crossings of a check. Crossing. What do you mean by crossing? Crossing, how do you cross? 2 parallel transitive lines across the face of the check constitute a crossing. So as per the Bills of Exchange Ordinance says, crossing means that you have to draw 2 parallel lines on the face of the check, not on the back side or not in anywhere, on the face of the check, 2 parallel lines and transitive across the face you have to write. That constitute a crossing. The drawer or any other holder by crossing check by crossing a check instruct the collecting bank to collect the check to a bank account. So that is an instruction given to the bank by putting a cross, by putting a crossing, that means two parallel lines on the check. It is an instruction. It is an instruction given to the collecting bank. So who can cross the check? Any holder of the check can cross. Drawer or any holder can put a crossing, right? Crossing, if the crossing is there, that gives an instruction to the collecting bank not to collect the check, not to pay the check over the counter, but to collect that into account. So that is the instruction. So if the bank fails to observe this order, the customer, that means the account holder, can object to the amount to be debited to his account. The bank has to bear the loss. So what happened if the check is crossed? If the check has been paid over the counter, the customer, that is the account holder, can object to that payment. So he can demand the money that the bank paid over the counter, and in a situation like that, the bank has to bear the loss. So crossing is a material part of the check. So therefore, the crossing, it is considered as a material part of the check, which gives clear instructions to the bank to pay the check to account, or collect the check to a account, not to pay over the counter. So that is the crossing as per section 76 of the Bills of Exchange Ordinance. Then there are several types of crossings. So as per the section 76 of the Bills of Exchange Ordinance, we can identify mainly two types of crossings. Number one is general crossings. Number two, special crossing. Number one, we'll see number one, general crossing. General crossing means two parallel lines across the face of the check, with or without word, not negotiation. So it's like this. If it is a general crossing, there are two ways that you can do. You just draw two parallel transessive lines on the face of the check. That is a general crossing. Or you just you put two parallel transessive lines on the check, and in between these two parallel lines you can write not negotiable. So with or without word not negotiable, if you write two parallel lines on the face of the check, that is considered as a general crossing. What does it mean? If there is a general crossing, it is a instructions to the collecting bank not to collect the check not to pay the check over the counter. But to collect it to account. So that is the instruction. So then the other crossing, that is special crossing. Special crossing, there's addition. So what is that? Two parallel lines are there, same thing, two parallel lines on the face of the check, that is also there. But in between these two parallel lines, we write a name of a bank, or sometimes name of a bank and a branch name also. So that constitute a special crossing. So example, the example I given here is two parallel lines on the face of the check, and in between these two parallel lines we have written Commercial Bank Nugegoda. So the bank name is mentioned and the branch name also mentioned. So what is this? What is the difference between general crossing and the special crossing? If it is a special crossing, remember it is again an instructions given to the collecting bank. So what is the instruction here? This is a special instruction. What is this special instruction? It says this check should not pay over the counter. Number one. This check should be collected to an account. That is number two. And that check can be collected to an account maintained at the specific bank mentioned in that crossing. That is commercial bank. Not only that, if a branch name is mentioned, then that the check can be collected only to an account maintained at that particular bank, that particular branch. Now, in this matter, it is commercial bank, Nugegoda branch only can collect the check to account as per this special crossings given here. So that is the difference between the general crossing and special crossing. So this is very important to understand the crossing and also the difference between these two, and also the law related to crossing. So I know that as bankers, you may have seen, observed, you may have dealt with a lot of crossing cross checks. But what is the law behind this crossing? So what is the liability on the collecting bank if we don't observe this crossing? So these things, or what are the law? What is the act applicable? That is Bills of Exchange Ordinance number 25 of 1927. And what is the section applicable? That is section 76 of the Act, or the Bills of Exchange Ordinance. These things that you now understand the background of the crossing and the law applicable to crossing. So it's better to know at least the law applicable when you are dealing with cross check next time. So that is about crossings. So then there is another crossings that we use, that is not negotiable crossing. That means between two parallel lines of the crossing that we put the word not negotiable. So what is the effect of this crossing? It's not a special crossing, it's a general crossing. So what is the meaning? Why do we put this not negotiable words? What is the effect of that word? So effect is this will not even though it is not negotiable, the words are there, it's not restrict the transferability of the check. So just because that we put the word not negotiable, it will not restrict the negotiability of the check. So check is still negotiable. But holder shall not have the better title than the previous holder. So the present holder, if it is not negotiable cross check, will not have a better title than the previous holder. What does it mean? It means we'll say we assume that the previous holder had a bad title. So bad title means that that he has not got the check to his hand in legal manner. So we say that the previous holder has stolen the check from somebody else, right? So therefore he has no title. Then we say it is a not negotiable cross check, and he negotiates the check to another person, the present holder. The present holder will not get a better title than the previous holder. In other words, the present holder will not get a title for the check because the previous owner had a bad title for the check. So that is the effect of the not negotiable check. Holder shall not be capable of giving a better title than the previous holder's title. The holder who has the defective title cannot retain the check against the true owner. That is the other important point. So that the holder who is holding a not negotiable crossing has no better title or has no legal right to hold the check. He has no legal right for the check. So actual owner, the true owner, has the right for the check. So therefore, the money or the value of the check should go to the true owner, not to the holder. So that is the different bit. That is the effect of the crossing of not negotiable. So the case, we have a case here, decided case, Nagpur Pichai versus Kanapati Pillai 1963 case. That is relevant to the negotiable, not negotiable crossing. So then there is another crossing that we practice, we use in the banking, uh, banking, uh, uh, the practices banking business, that is account payee crossing, account payee crossing. So only the payee's account can be credited in this crossing. In two parallel lines we put account payee words, two words, account payee. So it is called account payee crossing. So this you must remember, this is not in the bills of exchange ordinance. In the bills of exchange ordinance, this has not been accepted or mentioned. So there's nothing called account payee crossing. But this is a practice developed by the bankers. So bankers, we use this, right? We put two parallel lines and in between we write the account payee. So what is the instruction given to the bank? So in a situation like, in a crossing like that, so the account, the check cannot be credited to any other accounts, only to the payee's account it cannot be credited. So that in that other words, it restricts the transferability of the check. Only the payee can take the money of the check if it is crossed as account payee only. So that's why we say it's that has been developed by the bankers and the banking business, in the banking business, which is not mentioned in the bills of exchange ordinance. However, it has been now recognized as a method of crossing the check. So next one, who can cross the check? So next one, who can cross the check? So now initially the drawer or payee or any subsequent holder can cross the check. The crossing at the time of issuing the check, the drawer, the person who draw the check can cross, or the drawer can issue a open check, and later the payee who holds the check can cross, or payee also can negotiate the check to any holder. That holder also can cross the check by drawing two parallel lines on the face of the check. So who can cross the check? Drawer, payee, or any holder. When a check is crossed, holder can when the check is uncrossed, holder can cross the check generally or specially. So the holder can, if it is a cross check, if it is an uncrossed check, payee or holder can cross. He can cross specially or generally. That's number two. Number three, when the check is crossed generally, a holder can cross specially. So that means the check is initially crossed. It's a general crossing. That means two parallel lines only. So later on, the holder can write a bank name in between two parallel lines. So that means now it is a special cross check. So that is also possible. When the check is crossed generally or specially, the holder can add words not negotiable. So if it is a cross check, or if it is a cross check, whether it's a specially crossed or generally crossed, the later on any holder can add not negotiable words. Then when the check is crossed specially to a bank, that bank can cross specially to another bank for the collection. That is very important. Another part, if the check is crossed to a specially crossed to a bank, that bank can cross the check to another bank specially. There is a possibility like that. When the uncrossed check or special cross check is presented for the collection, that the bank can cross the check specially to the same bank. So when a check is presented for the bank, crossed or uncrossed, the bank can cross the check for especially cross to themselves. For example, if it is uncrossed check, if it is presented for the payment to the commercial bank, bank can cross the check, especially to the commercial bank. So that is also the possible. So then collection of checks. Next topic, next subtopic is collection of checks. Since the time is now 5:13, we'll stop at this point. Right. If you have any questions that you can ask now. There are no questions in the chat box. Any questions? Okay. Seems to be there are no questions. So we'll start from this point on next Sunday, 1 o'clock. Thank you for your participation, but I would like if you can actively participate on next time. You can ask questions, you can discuss, you can answer my questions, but I didn't see that you are actively participating today. But please participate actively on next Sunday onwards, because I have now shared the notes. You can read the notes, and if you have any questions on the next day, you can ask. Again, thank you very much. We'll meet on next week on the same time. Thank you.